All right, hello and welcome again. Disability Law Show. So good to have you on the show for the next 30 minutes. John Scholes here beside James Fireman, who does all the heavy lifting, this and the radio show as well. You've seen him and heard him before. You want to reach out to James anytime, 1-855-821-5900, help@disabilityrights.ca. There's also the website called mydisabilityquestions.com. Free, anonymous, ask your questions there. They will get answered by either James or a member of his very capable team. Partner, Samfiru, Tumarkin, LLP, the most positively rude law firm in the country. You can check that at any time. Lots of stuff to get through in the show today. What you need to know about common LTD insurance tactics. That is coming up a little later on in the show, James. But good to see you again, brother. We always start off with the week that was. What's happening in your camp?
Well, so I want to talk about a case that I have right now, a mediation that was supposed to be coming up. And the way it relates at large to many of the people who may be watching at home is in the expectations about what we are doing when we start the legal claim. So when we start a legal claim, obviously part of what we're looking to do is to get the benefits that you're entitled to. That goes without saying. But as a matter of course, we are always going to also include a claim that will be for punitive damages and general damages. Now, sometimes that is not a case that can be made out. But what we're talking about there is situations where the insurance company has not acted in good faith. They have a duty to treat all of their claimants in good faith, which essentially means to act fairly. And so that's part of the process. That's part of the legal process, is to look through the insurance file and to make sure that everything that they've done has been on the up and up, that they've treated the claimant fairly, that they've done a proper and thorough assessment before coming to their decision. We're also going to look at how their decision has impacted the claimant. If their process has been unfair, has that had a particular impact on the claimant that has caused damage, that has caused them to lose the enjoyment of life, as the courts like to refer to it? And if so, there's potentially damages for that, what you might think of as pain and suffering. Okay. And so we are going to include this in every claim that we're going to bring, as a matter of course, as I mentioned. Now, there are several cases where that will not be able to be made out, but generally at the start of a claim, you don't know how that's going to unfold. You don't know what you're going to find in the insurance file, and so that's something that we're always looking for. In this particular case, I have a lady who came to me several months ago because she had been cut off, and when I got the file, it was very clear that when the insurer made the decision, there was really no justification for it. All of her treating doctors for both physical and psychological issues were saying that she was absolutely not ready to return to work and that it would be detrimental for her if she tried, and yet the insurer still cut her off. So she came to me and we brought a legal claim, and we had a mediation scheduled for the near future, but before we got there, the insurance company said, okay, well, we'd actually like to do assessments. Now, question why they're waiting to do assessments after we start a legal claim as opposed to before they actually make the decision to cut off her benefits. That's when it would have been appropriate, when they needed the information to actually make the decision about what was happening. And yet they wait until after we start a legal claim. And when they get the results back, sure enough, it shows from their own doctors that she's been disabled all along. And they say, okay, sorry, our bad, we're going to reinstate the benefits. And that's great. That's what they should do. They absolutely should be reinstating those benefits. But then I'm asked, okay, well, so can we just wrap up this claim? We'll pay you a few bucks in legal costs, and that'll be that. No, absolutely not, because this claim isn't just about the benefits. The claim is also about the conduct of the insurance company and how that impacted my client. Now, I'm not going to say to my client, we have to continue forward if the benefits have been reinstated. That's obviously a choice I'm going to give to my client. If they just don't have it in them to go forward, then it's not for me as their lawyer to say, oh no, you have to. This is obviously my client's claim, not mine. But I talked to my client about it, and she was absolutely 100% on board with going forward, because the insurance company shouldn't be allowed to just say, oops, our mistake, here's what you should have had all along anyway, if the issue isn't just that they made the wrong decision, but the issue is that their process was fundamentally flawed in a way that was unfair to my client. And that's exactly what happened here. So we're moving forward with the claim, even though her benefits have been restored and she's continuing to get them on a monthly basis.
Talk about the mediation for a little bit. This process, is it mandatory? Is it something that your clients generally like? Is it good for the whole process in general?
Well, that's an excellent question. So as it turns out, there are certain jurisdictions in Ontario where it is mandatory, but most other jurisdictions in Ontario and across the country are not. In Ontario, it's Toronto, Windsor, and Ottawa, I believe, at this point. And so if you bring a claim in one of those jurisdictions, you have to go to mediation. And in fact, this was the case here. And so we will be proceeding to a mediation, but it's going to be postponed by a few months, and they want to use someone as cheap as possible. So be it. That's up to them. Not a surprise. Insurance companies like to do things on the cheap.
Now, their assessment, is that a case where your client, do they have to go to the assessment? We've talked in past shows that the client doesn't necessarily have to go to a clinic that is suggested by the insurance company. How about the assessment itself? They say you got to go. Do they have to go?
So there are two time periods that you want to look at when answering that question. The first is while the person is on claim, or even after if they've been denied, but before they've started the legal process. During that process, you really want to go to any assessments. Now, if they've cut you off, you don't, strictly speaking, have to go. But if they're willing to spend the money for an assessment after they've cut you off or denied you, then there's at least a chance they might reinstate you if you get a positive result from their doctor. So before litigation, you have to go to any assessments for sure. During litigation, you still have to go, but it's for different reasons. It's not because the policy says so, it's because the law says so. And so the insurance company, in defending the claim, is entitled to get medical evidence. And so, as long as the expert that the insurance company is asking to assess my client is someone who's reasonably qualified to do it, as long as it's an expert in the field that my client is disabled from, then I'm not going to say no to that. I want the insurer to have information. And it's my experience that once we start a legal claim, once litigation has started, when the insurance company actually goes out and gets those medical examinations, more often than not, they're supporting my client's claim. And that's because those medical examiners are going to be scrutinized much more closely than the ones that are relied on in the claims process. And because of that, they tend to act more fairly. They tend to have less of a bias in their final conclusions. And my clients invariably have full support of their treating doctors. And so in that scenario, when you have an independent medical expert looking at this, where all of the treating doctors are saying that this person is disabled and cannot go back to work, it isn't surprising that the experts hired by the insurance companies are more often than not agreeing with that.
Is it always the assessment itself? Is it always for your clients somewhere they have to go and see this doctor, or is it sometimes a paper file that they look at? Is there always a person-to-person contact?
Well, so in the context of litigation, it's rare that you would see an insurance company just rely on a paper review. We see that all the time in the claims process. In the claims process, before they've been cut off, before the decision's made often, you'll see the insurance company send the entire medical file, sometimes to a doctor, sometimes to a medical consultant, which typically means not a doctor, just to get a medical opinion about where this person stands in terms of their disability. But once you start the litigation, I would expect if they're going to send it to anyone, it will be for an assessment.
I know you often talk about, before we move on to an email and some other things, I know you often talk about the reason why a lot of people are hesitant to reach out to you and the firm is they don't want to get hassled nonstop by this insurance company. They don't want to go through the rigmarole and wear them down even further. What's the reality when it comes to that?
Well, the reality is it's 100% on us. Once we start the litigation, once the client signs the retainer agreement hiring my firm, that moment we send a letter to the insurance company letting them know that we've been retained. And from that point forward, all communications from the insurance company has to go through my office. The insurance company is no longer able to contact the client directly. They have to contact us if they want to communicate at all, which is obviously a huge relief for most clients.
You cannot overemphasize how much of a relief that would be for your clients.
No, I mean, listen, I haven't been in that situation myself. All I can do is tell you what my clients say.
Right.
And invariably, there's at least some measure of relief. Often it's the most significant part for them. Often they're less concerned about what's going to happen with their benefits than they are just avoiding having to deal with the insurance company anymore.
Sure.
I'm not joking, though.
Yeah.
Legitimately, it is such a source of stress and anxiety for people having to deal with an insurance company that just the idea that they won't have to do that anymore is enough to convince them that this is in fact the right route.
Again, reaching out to James anytime, 1-855-821-5900, help@disabilityrights.ca, which the email we'll get to here in a moment. I did want to mention, though, pocketemploymentlawyer.ca. I know that's usually on our other show, the Employment Law Show, but the reason I bring it up, and James has referred to it as well in the past, there's a nice little robust section within that website about disability law. It will answer a lot of questions because there's so much interplay between employment law and disability law, so it's really a handy tool. Again, pocketemploymentlawyer.ca if you want to check that out. But an email, this one. First one from Philip. James writes in, says, I've been on LTD for almost 2 years, but was recently given a return to work date and planned by my insurer. My doctors don't believe I should go back yet and say that I need extensive physiotherapy before I can function properly. I don't understand how the insurer can push me to return before I'm ready. What should I do?
Well, first of all, let's understand the context here. So Philip is coming up on the 2-year mark, right, which we know is called the change of definition in the disability context. And what that really means is that at that point in time, the test that determines whether or not he's going to be entitled to continue to receive benefits is going to change. It changes from the own occupation test, are you disabled from your own occupation, to the any occupation test. Are you disabled from any occupation that you're qualified for by training, education, or experience? That is a more difficult test to pass. There's no question about that. And so once the 2-year mark is approaching, it's not uncommon to see insurance companies really look more closely at these claims to see if they can find a justification to terminate. And that's what's happening here. That's what's happening in Philip's case. Now, the issue here is that Philip's doctors are telling him that he needs to get more physiotherapy before he can return to work. It may be theoretically possible that Philip could return to work or return to maybe some other job after the 2-year mark and be able to manage for some period of time, even without getting this additional physiotherapy. But the question becomes, is that something that is going to be detrimental to Philip's long-term health? And what we know, I mean, listen, I'm not a doctor, but I've seen these cases hundreds and hundreds of times, and you know very well that if you don't get your therapy early on, the odds of being able to make a full recovery become lower and lower as time goes on. So it's critical that Philip has an opportunity to get the physiotherapy that he requires to be able to go through that and to get to the maximal medical recovery. That's the way they refer to it. And if he's not given that opportunity, if the insurer is forcing him to return to work early, one, it's going to be far more likely that he's going to be unsuccessful in trying to return to work. But two, even if he's able to do it for a short period of time, in all likelihood, he's going to suffer in his long-term health. There's going to be a price to be paid for that. And the insurance company can't put him in that position. He's entitled to make reasonable decisions about his long-term health. And if this is something that is jeopardizing that, he should be listening to his doctors. And that's really what it comes down to. The decision about returning to work is a medical decision. It's not a legal decision. Right. So it's not something that you take advice from, even from your lawyer, and certainly not from your insurance company or the claims handler from your insurance company. It's something that you discuss with your doctor. And if and when your doctor says you're okay to go back to work, that's when you go back to work. But if they tell you that you're not medically fit to do it, and especially if they say that returning to work is going to have a detrimental impact on your health, then you absolutely should not be returning to work at that time.
Something I kind of mentioned a short time ago, and this might come down as a result of this. The insurance company say, okay, we get that you need more physical therapy. Go to our guy. We want you to go to our guy. You have to go to our guy. What do you say to that?
Well, I say absolutely not. Why would you? Why would you go to someone being recommended by the insurance company? You have to think about, why the insurance company is recommending one particular treatment provider over another. They have an agenda. This isn't a secret. Insurance companies, they're looking to find a way to cut you off. They're looking to find a way to terminate your benefits as soon as they can. And so every aspect of the claims process is designed with that in mind. Now, they do need to find a justification for it. And so if you have an obvious disability, it's making it harder for them to do that. So one of the things that they'll do is they will find treatment providers that they know are reliably going to tell them that over time you've improved sufficiently that you can return to work. And so what do? They send you to this treatment provider. They say, okay, you're going to go here for 8 weeks of therapy and then we'll reassess at the end. And this treatment provider, knowing that they're getting all of this work from this insurance company, knows that they're being judged on that basis basis. And so sure enough, 8 weeks later, they say, oh yeah, look at all the ways that they've improved. And even if they really haven't, sometimes you have to look really closely, they're going to cherry pick out the areas where there has been improvement. There might be 16 different things that they measure you on at the outset. And then at the final report 8 weeks later, they say, oh yeah, look at these 3 areas where there's been improvement. And you look at the other 13, and it's either stayed the same or gotten worse. So you can read between the lines what their motivation is in writing that report.
It's like, go to our body shop when you have a car accident type of thing.
Absolutely. So, the practical advice here is when you're in that situation, when you do require therapy, then you want to make sure you get a recommendation from your own doctor. Go to a clinic that, or even if you know someone who has been through therapy before and had a clinic that really worked well for them and it's reasonably close by, sure, why not? As long as it's somewhere that you believe you can trust and that it doesn't have a relationship with the insurance company, that's fine. But don't go somewhere just because the insurance company is saying this is the place you should go.
One more quick one before we go to a break. What happens if you attempt to go back to work? Doesn't work, you got to go back on claim.
Sure. Well, I think we're dealing with this in another question later on, but that's a recurrence issue. Right. And so the vast majority of policies are going to have a recurrence clause in their policy, which allows you to return to work. It allows you to attempt to return to work, and if you're not successful, then you can go back on claim. You can get your monthly benefits on an ongoing basis without having to start the process all over again, without having to do those initial application documents, without having to go through the 4 or 6 month waiting/elimination period before your benefits become payable. So if you attempt to return to work and you're not successful, that's something that's available to you. Whether or not the insurer honors that is another question, of course.
Short break and we will get into that topic, common insurance company tactics. That is on the way, so stick around for it. In the meantime, 1-855-821-5900, help at disabilityrights.ca. Anytime to reach James and his crew. We'll continue the Disability Law Show. Stand by. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Thanks so much for hanging in. Disability Law Show. John Scholes along with James Fireman. You want to reach James anytime. Samfiru Tumarkin LLP. Partner Samfiru Tumarkin, the most positively reviewed law firm in the country. 1-855-821-5900 and help at disabilityrights.ca. Okay, James, let's whittle our way through these. What you need to know about common LTD insurance tactics. Number one, we'll go through this one quickly because we just talked about it, but insurance companies will refer and prescribe claimants to seek treatment from their own providers.
Yeah, again, just to rehash what we were just talking about in the last segment, insurance companies have an agenda. They are looking for ways to cut you off, to terminate benefits, and so they're going to use treatment providers that they know are going to give them answers that will help them to do exactly that, to cut off your claim and your benefits. So what you want to do is get a referral to a treatment provider that you can trust, either from your family doctor or from a close friend or relative that has had success at a different place.
Number two is this: adjusters will often take information out of context to justify ending benefits.
Yeah, there's a few ways that this can happen. Right. So one of the ways it can happen is during conversations. Insurance companies will be calling you nonstop over the course of the claim, especially early on. And so there are all sorts of phone calls that they will have with you, and they're going to take notes. The claims handler is going to take notes and summarize those in the claims file. One of the things that they like to do, though, is take things that you say out of context and suggest as though it means you're improving or getting better. For example, hi, how you doing? Oh, I'm okay.
Great.
How are you? Right. And, saying I'm okay, or the insured says he's okay. I mean, listen, that's an obvious example and is something that you can rebut pretty quickly with decent medical records, but it is something that we see all of the time. So you have to be careful when you're talking with your claims handler. You have to be a little bit defensive. That doesn't mean you have to be rude by any means, but understand that the claims handler for the insurance company isn't your pal. They may be a nice person and they may be friendly to deal with, but they have an agenda. The agenda is to help their employer. To help their employer do what? To cut off your benefits. That's what they're there to do. So you have to have that conversation understanding that your objective is to protect your benefits. And so you have to be careful with the words that you are using. Choose your words carefully when you're talking to the claims handler. The other way it can happen is simply by the claims handler cherry picking different words or different phrases or even results in the medical file. And we see this all the time. So for example, you may have someone who is seeing several different specialists and a GP. And perhaps one specialist is saying, oh, well, there's this issue here. And another specialist in a completely unrelated area is saying, oh, well, we don't actually see any issue. There's nothing that I can see here. And they'll say, okay, well, claimant went to see neurologist and there were no issues. As though that answers every question, although there's an orthopedic surgeon that's talking about all the different issues in the spine, in the different areas, the lumbar spine, thoracic spine. But the neurologist says that they're having no issues and therefore must be okay. Or even a yearly checkup where the person is having let's say an issue with their mental health, and they, in the yearly checkup, blood pressure is okay, pulse is okay. Well, your vital signs were looking good, as though this were an issue about whether your vital signs were okay. I have seen that happen, though. I'm not joking. I've seen claims handlers cherry pick any positive information they can out of the claims file. Now, there really isn't much that you can do about that, other than don't take their word for it. Oh. When the claims handler says to you that the medical file says that you're not disabled, don't say, oh, well, okay, that must be so, especially if, number one, you feel like you're still disabled, and number two, your treating doctors are still telling you that you're disabled. If that's the case, then you better believe your claims handler is doing some mental gymnastics in order to get from A to B. And usually, it's a pretty meandering route that they take. And one look at the claims file, and it's usually pretty clear what they've done in order to do that.
We're talking common LTD insurance tactics. Next one is this. All or most communication will be conducted over the phone by the adjusters.
That's the default for most insurance companies. Okay. They like to do things over the phone. That's something that you should address very early on. As a claimant, you want to make sure that every conversation you have is reduced to writing. Now, preferably, you're going to ask the insurance adjuster to put all communications in writing, to communicate by email anytime that they want to talk to you. I would make that a request very early on that you're asking for. Does that mean the insurance company is going to agree and communicate in writing all the time? No. Very often they'll refuse to do that, but that's okay. If they refuse to do that, then there is a way around that. All you do every time they call is you say, hold on just a second. Go grab a pad of paper and a pen, or if you're by your computer, start typing, and take notes. Take detailed notes of the conversation that you're having with the claims handler. And if need be, ask the claims handler to slow down, because you just need to take a few more notes. When the conversation is over, send an email to the claims handler setting out the substance of the conversation that you've had. This way, anything that the claims handler says to you that suggests things are one way, that suggests that your benefits are going to end if you don't do this or don't do that, you're going to be able to put that in writing so that there is a record in black and white, contemporaneous with when they said it, that shows this is what they said. And if the insurance adjuster, when they get that email, doesn't immediately respond and say, oh no, I didn't say that, then they're going to be stuck with it going forward, and that's going to be a problem for them if they say anything that's at all inappropriate or incorrect. Yep. So take notes, send those as soon as the conversation's over.
One more of these. Frequent vague references to the future and return to work plans. Hello.
Yeah, so there's a few purposes for that.
Okay.
One of them is just to try to get you to say something that's going to be agreeable that they can use against you. So, they'll say, all right, so we're going to start looking at a return to work plan, and, let's take a look. What are some of the, different occupations or fields that you might be interested? If you're looking at, beyond the two-year mark in the any occupation period. And so you'll say, oh, well, I always wanted to be a writer, or I wanted to do this or do that. And the notes are going to say, okay, claimant is looking to being a writer, and, that's the new career path or whatever it is. So that's part of it. They're looking to just put a positive spin on it and to put words in your mouth that are suggesting that you're okay and are ready to get back to work. One of the other reasons, though, is a little bit more subtle than that, and it's really just to make the idea that going back to work is inevitable. In other words, they're going to start talking about it as though this is obviously something that's going to happen. And if they do it enough, and if you don't challenge that, then eventually a lot of people are just going to accept that this is just what happens. You go on claim for a while, and even if you're not better, I guess you have to go back to work because that's the way they keep talking. But that's not the case. You are entitled to stay on your benefits until you're 65 if you remain disabled. That's just the way the policy works. And so if your claimants handler starts talking to you about return to work plans, and you know that you're in no way able to go back to work, your doctors are still telling you can't go back to work and you don't feel like you can go back to work, then don't agree with them. Say, listen, that's all well and good, and hopefully one day I'll get there. But right now, I'm not ready to go back to work, and my doctors are telling me the same thing.
Short break, mydisabilityquestions.com. I mentioned it. That's where we're going after the break, so stick around for it. Got a couple minutes to go. 1-855-821-5900 to reach James and his crew, and help@disabilityrights.ca. We're coming right back. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Couple minutes to go. I mentioned mydisabilityquestions.com. That is a place to ask your questions, free and anonymous, so we'll make haste on this one. James comes from Carroll, says, I was on long-term disability years ago at a different employer. After a successful return to work, unfortunately, I now appear to be experiencing debilitating migraines. While I was approved for LTD in the past, I'm unsure if I will be now. Are there different kinds of disability insurance policies, or are they all similar?
By and large, they are similar.
Okay.
When we are talking about disability policies on this show or on the radio shows, we are usually talking about a fairly standard group disability policy. But first and foremost, if you ever have any concern about what your policy covers, go to your policy, ask for a copy of the policy, either from your work or from your claims handler, and look at it very carefully. Usually in substance, in terms of the test for whether or not you're disabled, that tends to be very similar from policy to policy. There can be some differences. Obviously, there's differences in the amount you're covered for. Mm-hmm. Sometimes it's 50%, sometimes it's as much as 70%. It can be anywhere in between. And then there are some executive policies where we see the own occupation period go all the way through to 65. Occasionally, you'll see policies, if they're private policies, sometimes you'll see them go beyond 65 to 70, wow, even 75. But the vast majority of policies we're looking at are fairly standard, and typically the advice we're giving can apply to almost all of them. One area of exception is the pre-existing exclusion. You're going to find that in pretty much every LTD policy, but the substance of it, the way it's applied, can vary reasonably significantly from policy to policy, so that you want to be extra careful about looking at if it is a live issue in your case.
Carol, appreciate you reaching out. We are just about done for this show. You can continue to reach out to James and his team. Again, 1-855-821-5900, help@disabilityrights.ca, or just disabilityrights.ca if you want to catch a station that carries our radio show. We'll join you up again, and James will be back in another time as well. Thank you so much for joining us on the Disability Law Show.